Case.
The case number IT 95AI. The prosecutor versus Duško Sikirica.
I'll hear the appearances.
Good afternoon, Your Honor. Brenda Hollis, Dirk Reineveld, and Daryl Mundus appear on behalf of the prosecutor.
Good afternoon, Your Honor. My name is Veselin Londrovic. I am an attorney from Bijeljina, and at the initial appearance, I shall represent the accused Duško Sikirica.
Very well. As you say, this is the initial appearance of this accused, and the first matter to be dealt with concerns the accused's pleas to the indictment. Mr. Londrovic, two questions for you, please, if you would deal with them. First of all, I take it that the accused has received a copy of the indictment in a language which he understands.
Yes, Your Honor.
I also take it that you've had the opportunity of going through it with him so that he understands it.
Yes, Your Honor.
As you also know, the accused must enter a plea to the indictment within 30 days of today's date. Or he may do so today. So I must ask you this, does he wish to enter pleas today to the indictment, or are you going to ask for an adjournment for him to do so?
Your Honor, I have acquainted the accused with his rights according to Article 92 in the Rules of Evidence and Procedure, and he will enter a plea today.
Finally, this. Before he enters his plea, the accused can have the indictment read out in full in court, but he can waive that right. So I must ask you, does he want the indictment read out in full, or does he waive the right?
Your Honor, I assumed that the indictment would be read in full, and I did not discuss this matter with the accused. I did not ask him whether he wanted to waive that right.
Would you like to have a word with him now?
If you will permit me a minute. Thank you, Your Honor. Your Honor, the accused Duško Sikirica waives the right to have the indictment read out in full.
Thank you. Mr. Sikirica, would you stand, please? Your counsel has said that he's discussed the indictment with you, and you wish to enter pleas today. Is that right? Speak it to the microphone so that it's recorded.
Yes, that's correct.
I'm now going to read the counts in the indictment to you, and you should enter a plea to each. Kindly confine your answers to guilty or not guilty. The counts in the indictment relate to events in Bosnia and Herzegovina in the period between April and August of 1992. Count 1 charges you with genocide, punishable under Articles 4.3a, 7.1 and 7.3 of the Statute of the Tribunal. How do you plead? Guilty or not guilty?
Not guilty.
Count 2 charges you with complicity to commit genocide, punishable under Articles 4.3e, 7.1 and 7.3 of the statute. How do you plead? Guilty or not guilty?
Not guilty.
Counts 3 to 5 relate to events in the Priador area and specifically in the Karaterm camp in the period between the 24th of May and the 30th of August 1992. Count 3 charges you with persecutions on political, racial, or religious grounds, a crime against humanity, punishable under Articles 5H, 7.1 and 7.3 of the statute. How do you plead? Guilty or not guilty?
Not guilty.
Count 4 charges you with inhumane acts, a crime against humanity, punishable under Articles 5I, 7.1 and 7.3 of the statute. How do you plead? Guilty or not guilty?
Not guilty.
Count 5 charges you with outrages upon personal dignity, a violation of the laws or customs of war, as recognized by Article 3.1c of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 and 7.3 of the statute. How do you plead? Guilty or not guilty?
Not guilty.
Count 6 to 9 relate to events in Karaterm camp on the 25th of July 1992, and you're charged as follows. Count 6, murder, a crime against humanity, punishable under Articles 5A, 7.1 and 7.3 of the statute. How do you plead? Guilty or not guilty?
Not guilty.
Count 7 charges you with murder, a violation of the laws or customs of war as recognized by Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3, 7.1 and 7.3 of the statute. How do you plead? Guilty or not guilty?
Not guilty.
Count 8 charges in inhumane acts, a crime against humanity, punishable under Articles 5I, 7.1 and 7.3 of the Statute of the Tribunal. How do you plead, guilty or not guilty?
Not guilty.
Count 9 charges you with cruel treatment, a violation of the laws or customs of war, as recognized by Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3, 7.1 and 7.3 of the statute. How do you plead, guilty or not guilty?
Not guilty.
You may sit down. Ms. Hollis, it would be convenient to discuss the future progress of this case. The position is this, that this accused is charged, of course, with a number of other accused in the same indictment. And the trial for two of those accused, Messrs. Doshin and Kulunzia, has been set down to start on the 6th of November. And so my first question is this. Will the prosecution be ready for trial against this accused on the 6th of November?
Your Honor, the prosecution at this point can tell you that we will endeavor to be ready, but we cannot assure the court that we would be ready.
Well, it's clearly desirable, if possible, that the accused is tried with others on the same indictment. May I inquire what difficulties there may be in being ready for trial?
Yes, Your Honor, thank you. Your Honor, it is the prosecution's preference that the three accused be tried together because this accused, being alleged to be the commander, would be held, in our view, accountable for the crimes for which the other two are charged as well. So that a trial of all three together certainly would be the best use of judicial resources and also the best for witnesses. The issue that we find ourselves facing, Your Honor, is that this accused was, in our view, the commander of this camp throughout its existence, and therefore, in our view, responsible for all the crimes that were committed by everyone, both who worked in the camp and who came to the camp. This enlarges the scope of the disclosure and the scope of the Rule 65 TER submissions that the prosecution must make. To the extent there is overlap with the other two accused, which there is, then of course the submissions would be the same. However, there are other incidents in the camp and other charges that would be in addition to those facing the other two accused. The prosecution has already set into motion searches through our databases to prepare ourselves to provide complete disclosure regarding this accused for all incidents within the Karaturm camp. Based upon the results of that disclosure, we would be able to prepare the Rule 65 TER submissions. Because of other requirements that we have within the Office of the Prosecutor, we have asked for time estimates on the completion of these searches. The completion of the first two categories of searches, which we have requested, the completion of those searches would be on the 28th of July, according to the information we have received from our computer personnel. We have two additional categories of searches to ensure that we capture all relevant evidence for the Karaturm camp. Those searches would not be completed until sometime in August. The plan that the prosecution has in place, Your Honor, is that as these searches progress, we will receive the product of these searches as they are created. We will then incorporate the product into disclosure and into Rule 65 TER entries. However, we could not complete that process until the searches were completed. So we believe in order to complete that process comprehensively, we would be looking at a September or October time frame. We had indicated, Your Honor, regarding the other two that we felt for a comprehensive 65 TER submission it would be approximately the same time frame. But that is what we have estimated based on the time for the searches and the time to put together the results of those searches.
Well, the date for disclosure under the rules would be the 4th of August for the supporting material.
That, Your Honor, we have requested in regard to the supporting material, we have approximately 30 pages of the supporting material that still need to be translated into a language the accused understands. Approximately 2 weeks ago, we submitted that material as soon as we were aware of the arrest. We submitted that material for translation. We requested from the trial team that that material be provided to us by the 10th of July. I have endeavored over the last several days to determine the status of that translation request. I have been told today that through some process somewhere, the translation unit was told a later date, and that as of now they feel they cannot give it to us until the 21st of July. We will try to expedite that. In the meantime, all but 30 pages of the supporting material will be provided to the accused next week in a language that he understands. And then we will be awaiting the BCS on the last 30 pages. So the supporting material we will provide within the time period. It's the 66AII disclosure and the 65 TER disclosure and submissions that require this expanded search, Your Honor.
Well, it's a matter for you to consider what course you are going to take with this trial and arranging it, if possible, so that it takes place at the same time as the trial of the others, because that really would be, as far as I could see, in everybody's interest. You may like to consider restricting the scope of the trial as far as this accused is concerned, rather than widening it. As I say, it's a matter for you to consider, but obviously there are strong arguments, which you've already mentioned, for having him tried, this accused tried at the same time as the others in the indictment.
And Your Honor, we certainly don't want to expand the scope beyond what is already charged. In regard to the existing charges, the prosecution certainly takes your point and will review the existing indictment and the incidents in light of your comments, Your Honor.
But that, if you can set the timetable going before the 4th of August, it would mean that there may be a reasonable chance of this trial taking place in November. I'll hear what Mr. Loveridge has got to say about it in a moment.
Your Honor, I would just reiterate regarding the supporting material, it is our intention to provide all of the supporting material, including that 30 pages, before the 4th of August. We hope no later than the end of the 3rd week in July.
Is there anything you want to say in addition about progress before I turn to the defense?
Your Honor, I will indicate to you that in regard to disclosure under 66AII, that there is overlap as far as witnesses are concerned between this Karaterm case and the case involving Kovachka et al. And to the extent that there is overlap in the witnesses, which there is, then we will be able to expedite the disclosure because we've already prepared the comprehensive disclosure for the Kovachka case. So we believe that between 15 and 18 witnesses may be common witnesses, and we would be able to expedite the 66AII disclosure for those witnesses.
Thank you. Mr. Londrovich, clearly, if at all possible, it's desirable that the trial of this accused should take place at the same time as the trial of the others on the same indictment, which means by the 6th of November, or on the 6th of November. Clearly, any preliminary motions, as you know, have to be in within 30 days of disclosure, which will be a date sometime in August, I anticipate. Beyond that, are you going to be in a position for trial by the 6th of November?
Your Honor, first of all, I have to say that I have still not been selected as the defense counsel of Mr. Duško Sikirica. I have been asked today by Mr. Duško Sikirica and the registry to appear at his initial appearance, and Mr. Duško Sikirica is still considering which of my colleagues will be his lead counsel. I have information to the effect that the accused Sikirica has received only the indictment so far, and I trust that the prosecution will respect the terms of Rule 66A1I and will disclose the material within the prescribed time limit, so that I would not like to take the responsibility of saying on behalf of the defense counsel of Mr. Sikirica whether or not they will be ready for trial by the 6th of November 2000, because I'm not certain that I will be in the defense team. Of course, I fully understand the endeavors of the chamber and of the prosecution to have a trial at the same time as the other accused.
Mr. Londrovich, I hear, of course, what you say about it. You should inform those who are going to undertake the defense that the trial chamber expects the matter to be ready for trial on the 6th of November. And if you are in the team, have that in mind yourself. Now, I'm going to consider any future dates. Is there anything else you want to say, Mr. Londrovich?
Only one more matter. I have advised Mr. Sikirica that in my opinion, this issue should be resolved within the next week, that he should not delay his decision or think about it too long about who his defense team should be.
That is clearly right, if I may say so, given the timetable. It's more pressing than usual. Yes, thank you. A status conference has already been arranged in the case of the other two accused for the 13th of September. This accused will be added to that. So the next date for hearing is the 13th of September. And Mr. Londrovich, perhaps you would pass that on to whoever is going to represent the accused, that the matter will be in court next on that date. Meanwhile, the accused will be detained in the United Nations detention unit awaiting trial. The matter is now adjourned.
All rise, veuillez vous lever.